Dan?
Good morning. I'll keep my remarks brief. Mostly they're kind of a preface of the article that was published by CIS. Asylum is the modern continuation of the age-old notion of sanctuary, providing safe harbor to those who would otherwise be persecuted by their fellow man. It is recognized by international law and treaty, and in the United States through adoption of the relevant treaties and incorporation into our immigration laws. Asylum is only one of the forms of non-refoulement or non-return which our immigration laws recognize. Its major counterpart is refuge, or the granting of refugee status. Both forms of protection are considered a kind of extraordinary relief. This is evidenced in many ways, including the substantive differences in the manner of the adjudication, as well as the forgiving of many grounds of inadmissibility that would render other aliens removable from the United States. People who ask for refugee status are outside of the United States. People who ask for asylum are either already in the U.S. or physically poised at its frontiers or ports of entry. The bases for seeking either refugee or asylee status are the same: having been persecuted or having a well-founded fear of persecution because of 5 designated grounds: race, religion, nationality, political opinion, or membership in a particular social group. The latter 2 grounds, political opinion and membership in a social group, have undergone a gradual but constant evolution because they are not further defined. This has resulted in expansion of what constitutes a political opinion or social group membership in ways to accommodate modern views of society, for instance, based on one's sexual orientation, but also in ways most certainly never contemplated. Thus, the lack of definition constitutes a weak point in the asylum system through encouraging administrative and judicial constructions of those terms, sometimes to the detriment of society at large. For instance, by granting protection to former gang, cartel, or cult members who purport to have changed their lives and views and are now being persecuted by those with whom they previously affiliated. Besides the physical location of the applicant, the other major difference between refuge and asylum is that refugee admissions are capped by law, which cap is set yearly. Asylum may be granted without numerical limit. This lack of a numerical limitation constitutes one of the weak points in the asylum system, in that it encourages individuals who might otherwise have no possible right or claim to enter the U.S. to attempt to game the system by fabricating stories of persecution which can be both hard to prove and hard to disprove. What is more, once having been in status for a single year as either a refugee or asylee, an alien may seek to adjust status to lawful permanent residence. These are powerful draws, and there are many documented instances of successful use of fabrications to achieve refugee or asylee status, which are only discovered after the fact. Just a few examples include the Tsarnaev family of Boston Marathon bombing infamy, the recently arrested Moroccan Al-Mehdi Fati, who planned to blow up a federal building and a university, even the maid whose alleged physical assault resulted in the arrest of Dominique Strauss-Kahn, former head of the IMF, against whom the charges fell apart when the evidence of her perjury on the asylum forms undercut her credibility as a victim and a complainant. Although a few anecdotes don't make a solid case, these are not the only signs that fraud may be rampant in the asylum system. Studies by officials within U.S. Citizenship and Immigration Services point to extremely high fraud indicators in the files which they have examined. Unfortunately, the studies never saw the light of day until they were leaked a substantial amount of time after they were undertaken. Some of the ways in which past abuse has been curbed were through the institution of a careful regimen of barriers to the final achievement of asylum to discourage malified or frivolous cases. The barriers include detention of arriving applicants and threshold testing of an individual's claim through a credible fear interview prior to formal adjudication of the application in chief. Many of those barriers have crumbled. Thus, the combination of expanding interpretations, the absence of numerical limits, and the effective elimination of some of the safeguards against abuse have in recent years resulted in a quantum leap in the numbers of applications. numbers of those granted either temporary relief through a finding of credible fear, and numbers of those finally approved for asylum. For instance, positive credible fear findings have jumped to 92% among cases decided on the merits. And not surprisingly, and almost certainly as a consequence, the number of claims has jumped almost 600%. Additionally, approval rates by asylum officers increased from 28% in 2007 to 46% in 2013. Within the immigration courts, even as findings of deportability by immigration judges have plunged in the past 20 years to an all-time low of about 50% of the cases that they hear. Conversely, approval rates by immigration judges in affirmative asylum cases have increased from 51% in 2007 to 72% in 2012. This is deeply alarming when one considers that these cases heard by judges are those which were previously rejected and denied by asylum officers. Considered dispassionately, there is grave cause for concern. It would seem that the extraordinary nature of asylum relief has been forgotten, and it is increasingly being perceived by administrative bodies and courts charged with overseeing the system as just another immigration benefit. Worse, fraud, missed opportunities to implement detection and prevention mechanisms to deter abuse of the program, and ill-considered expansion of some of the definitions are contributing to a recognition that the asylum protections in the United States are being so egregiously abused and mishandled that steps must be taken. To do so, first the administration must reinstate rigor into the barriers against abuse. They were put there for a reason. Second, USCIS must institute both pre- and post-audits of asylum cases, and as a separate subcategory, credible fear cases on a routine and recurring basis. Third, Congress must reject the statutory amendments, such as are embedded in the Gang of Eight Omnibus Bill, because they would aggravate, not ameliorate, the ills we are now seeing in the asylum system. And fourth and final, Congress should consider additional statutory reforms, including the possibility of extending the length of time before an alien may adjust to resident status after receiving asylee or refugee status, and perhaps through requiring a period of conditional residence before adjusting to full and final permanent residence. As you will hear, Professor Ting has developed one line of thinking into how the program might be reformed, and although my own thoughts have wandered down different paths, I recognize there are many paths which can lead us to the proper end, which is a reform of an important form of protection that should itself be protected from abuse so that compassion fatigue does not set in, so that the confidence of the American people in the asylum system can be restored, and so that the United States can continue to be a safe haven for those legitimately in need.